Alright, today's video is again on someone attacking 922.0. And like I said before, we're going to see 922.0 fall. I've already said this 100 times. I know everybody calls me crazy for that. I don't believe so. And now the next attack is stepping in, and it opens up new doors and new possibilities. So let's take a look at it and see what's going on. But before we get into that, don't forget to shop at OnlyTacticalFans@Shopify.com. I did get bam, both tourniquets back in stock again. So I got the one for your plate carrier, the Cat Gen 7. And I got your EDC tourniquet. This one fits small, this one fits large. This one's better for combat applications in case like you see a bloody body and like your handshake, you're like it's just easier to deal with big stuff. But it doesn't matter how big it is if you don't carry it with you. And that's where the snake staff comes in. This is an EDC tourniquet, nice and small, put it right in your pocket. You can buy both these at OnlyTacticalFans@Shopify.com. Anyways, let's get into the video. So what's going on so far? So we got SB 1071. I already covered that video, 2 days ago? And then we got HB 749, covered that video yesterday. You should definitely go check those out if you haven't. So these two are going under the authority of the state. They're not trying to essentially attack 922.0 or shut it down. They're the backup plan. They are, all right, so here's 922.0, here's the exceptions. Well, we want to put civilians into this exception and send them through. So, should our lawsuits fail and the Hughes Amendment stands somehow, it shouldn't, but let's pretend it does, well, these states are like, it doesn't matter whether you have the Hughes Amendment or not. Here's the exceptions. We're going to operate under these exceptions. There's no reason our civilians cannot buy machine guns. Operating inside the Hughes Amendment, that's their game plan. Now we have another private lawsuit popping up. It's Roberts versus the ATF. It's going after 922.0. It's going at it in a couple of different ways. They're saying they're trying to regulate a non-taxed item. So if it's a non-taxed item and they're trying to regulate, well, I don't know about you, but doesn't that sound a whole lot like an infringement? I mean, I haven't looked at the Second Amendment in a while, but I'm pretty sure it says shall not be infringed, which is pretty clear. And remember, they got this whole NFA crap going way back in the 30s by saying, oh, we're not regulating the firearms. What we're doing is we're taxing them. The NFA is just simply a measure to ensure that the tax is collected. So, the tax doesn't exist anymore on post-86 firearms. It doesn't exist anymore on SBRs, SBSs, silencers. What's left of the NFA that's actually a legitimate tax? And that's pre-86 machine guns, I believe destructive devices. I'm not really sure what's all in the NFA. The big ones for me has always been machine guns, SBR, silencers, stuff like that, because that's stuff I'd actually like to play with. As far as destructive devices and that, I don't really know a whole lot about it. So we're just going to swipe that off the board and pretend like all that other stuff doesn't exist. So the only thing left is post-86 machine guns. Now, I already heard them trying to argue that because to be an SOT, you have to pay the tax that justifies the NFA being in place. But that only needs to be in place if they're willing to justify that they can regulate these non-taxed items, because if they can't regulate these non-taxed items, well, that means they're not NFA items, which means that an SOT doesn't need to exist, because you'd be able to buy these on a normal 4473. So, what do we got here? The chicken and the egg. We're saying that the tax still exists because SOTs need to pay that tax. They don't need to pay it. You're basically paying a dollar amount to be tax exempt. So that's a whole nother word soup going on there. So they're saying that the NFA still needs to exist because the SOTs need to pay the tax, but if these aren't protected by the NFA or regulated under the NFA, which they shouldn't be because the NFA is just a taxing organization, well then the SOT shouldn't exist. So this is something that's going to be wrestled with. Well, damn! So, now we're going to get back to my case because this also plays in here. As you notice, I think it was like a week ago or so, the judges had requested more information, which means they have moved past combination of parts, which should have been a non-starter. I mean, I'm no legal expert here, but a combination of parts in my head means more than one thing. So you got to have more than one. It says parts because other places in the NFA it says part or parts. This specifically only says parts. So The point is, they've moved past that. If they've moved past that, oh, the auto key card is not a combination of parts, to affirm the conviction or remand the conviction, they have to explore, does Bruin apply to that? Now, in my circuit judge, and this is the same problem they're going to run into in this Roberts versus the ATF, is the circuit judge is essentially going to be like, Bruin doesn't apply to this because it's dangerous and unusual, so it's outside the scope of the Second Amendment. I should probably explain that real quick. All right, so dangerous and unusual is in a fray, right? That is a law that was put back before the Second Amendment. So that's how the Supreme Court justices have justified it, saying that because dangerous and unusual existed before the Second Amendment, therefore it's written right into the Second Amendment. It's right a part of American gun culture. The problem is it's a lie. It's incorrect history. And a fray is the stopgap to fill, you haven't broken anything yet, and you haven't hurt anyone yet, but you've terrified people. So the whole dangerous and unusual is, if I show up somewhere, say I go into a shopping mart, and I got a baseball bat, and I'm threatening people, that weapon is dangerous and unusual. Therefore, I can get in trouble for doing that because I've demonstrated, or not demonstrated, I've scared the public with a dangerous and unusual weapon. Now, put that same thing if I'm a batter at a batting stand. It's not unusual for me to have that. So therefore, if one of the audience people are like, I feel threatened by him because he had a bat, the phrase isn't supposed to apply because it's usual for me to have that there. So the weapon needs to be both dangerous and unusual. For example, I can't charge a cop with an affray because he scared me with the gun because it's usual for him to have the gun. So even though it's dangerous, it's usual for him to have it. Now, that's what the Supreme Court has been shoving through NFA regulations as. Dangerous and unusual existed before that. This all came from the Heller case. Like I said, it is incorrect history. I'd like to see it be corrected. Circling back around now that you understand that briefly. So in my case, the circuit judge was like, because my case was literally like the first test if Bruin is going to undo the NFA. Because we're like, hey, the Bruin decision just dropped, because it dropped shortly after I got indicted. So literally we were the first case. We're like, hey, the Bruin decision just dropped and said that the government needs to show text, history, and tradition around the time of the founding of the Second Amendment that machine guns were regulated. Well, we all know that machine guns got regulated in 1934. Like, that was the first time. And then specifically mine, post-86 machine guns, was 1986, which is not 1791 or any of the 1700s for that matter. So, they should have been like, oh, okay, so we're going to let Bruin apply, and then the government should have went back, oh, we're using Chevron deference and saying, yes, it does. And we should have been allowed to pin the ATF down and force them to use Chevron deference, and then when Chevron deference failed, because that failed shortly after, my case should have been thrown out. It honestly should have been thrown out at Bruin, but I'm saying if it was allowed to play out. But my circuit judge was like, no, absolutely not. We are not applying Bruin to this case because dangerous and unusual. So my case is already going, and we should know probably within 30 days because they're already working on my appeal. They're requesting information, which means they're working on it. I can't imagine it's going to take much longer than a month. So I'm guessing within the next 30 days we'll have an answer if they're going to affirm it or remand it back down. If they affirm it, they're going to say that dangerous and unusual allows the government to circumvent the Bruin decision. If they remand it back down, because we know they've went past a combination of parts, they're going to say that, oh, this could be a combination of parts. However, they failed to apply the Bruin decision. This needs to be remanded back down, and this case needs to be looked at or retried with the Bruin decision applied to it. So we'll have to see what happens there. I'm not going to lie to you. The fact that they've moved past the non-starter, which is an obvious off-ramp and a way to let all this go. I mean, maybe there's some sort of dissent, and they required that extra information to shut the dissent down, and the case is going in my favor, but they've moved past the non-starter. So either the person dissenting is like, I don't care if it's not a combination of parts, and due to the advertisement and all that this is still a machine gun. The advertisement plus the drawing comes together and equals a combination of parts. Combination of parts is metaphorical. Congress didn't actually mean multiple parts. It was just metaphorical for something they didn't have a way to regulate as like a catch-all. And if they do that, they're going to have to say that dangerous and unusual disqualifies Bruin from being applied here. So what does this all mean? We have a case in the 4th Circuit, the 6th Circuit, the 11th Circuit, and now the 10th Circuit, all wrestling around with, does 922.0, is 922.0 constitutional? Now understand, in my case, it wasn't directly 922.0. They went around and went the pre-laws before 922.0. It's real complicated, but essentially the outcome in my case will also affect 922.0. So let's pretend that the 10th Circuit is like, hey, you guys are right. These are non-tax items, and with the Bruin analysis applied to this, they can't regulate machine guns. Should that happen, and now we got the 11th Circuit involved, either way, no matter what, not all 4 of these circuits are going to come up with the same answer. There's going to be some sort of circuit split. They're going to disagree on something, which is going to basically force the Supreme Court to step in and be like, hey, this is our final ruling. My case will be the first one up there, because I'm already at the 3-judge panel, and the 3-judge panel is about to rule. So if I fail here, now we go to the 6-judge panel. It's possible the 6-judge panel may just uphold the 3-judge panel. From what I understand, a lot of times they don't like to already shut down what judges have already said. So that might push me right up to the Supreme Court. We may have 922.0 or Bruin versus dangerous and unusual at the Supreme Court very, very shortly. We'll have to see what happens. Anyways, so what's going to happen next? I predict very, very shortly we're going to see another lawsuit saying that AR-15s are protected by name, because when Illinois was doing their assault rifle ban, the Supreme Court preemptively basically stepped in and was like, how can we say that the most common firearm in America is not protected by the Second Amendment? So, if AR-15s are protected by the Second Amendment, what AR-15s are protected by the Second Amendment? Long ones? Short ones? Pink ones? Black ones? Now, semi-automatic AR-15s, AR-15s that are converted to single shot, full auto AR-15s, what AR-15s are protected by the Second Amendment? And the ultimate real decision would be all of them, which includes full auto. Now they might be like full auto is dangerous and unusual, but honestly, after the FRT triggers, it's kind of an irrelevant talking point. What are we regulating here? We can take a semi-automatic rifle and do essentially everything you can do with a full auto rifle. So what's the point? I believe that was a huge chunk out of the NFA. And now suppressors ain't taxed, short barrel rifles ain't taxed, short barrel shotguns ain't taxed. What do we got left? Like I've been saying for quite some time, even before my case went to trial, 922.0 is about to fall. The writing's all over the wall. If you just look at the wall and read the writing off of it, yeah, it's probably going to happen shortly that machine guns will just be sold at under a 4473 at a local gun shop. We'll have to see how it plays out. But anyways, we got multiple circuits involved. There will be another circuit getting involved, probably the 5th, probably the 11th as well. The 11th's already involved, but probably the 5th is probably going to be on what AR-15s are protected. Now, we're in a really good position. 922.0 is getting attacked by multiple angles. So even if the civil lawsuit fails, and it probably will, because it's already went up in the 10th Circuit, and the 10th Circuit has already, in the appellate level, said that, hey, the district court's wrong, because the district court was like, hey, the taxing on this is really weird, and there's no exception if something is made in the state and kept in the state, and the appellate decision was like, oh, no, the machine gun ban stands. So it's probably going to get denied. So even if it does get denied, we still got the states going under, where was it? Legislatively, well, we're going under judicially. So we have both of them going, which definitely increases the odds. The problem is states legislatively move slow. And bills like to get caught in the mud. So hopefully it'll go through, but we also have stuff going through judicially. Again, my case, this guy is suing now. All that stuff comes up. The point is we're getting multiple circuits involved. Anyways, let's just wrap up the video here because I'm pretty sure we covered everything. So if you'd like to help support the channel directly and you don't want to shop at only tacticalfans at Shopify.com, the next best way to do is go down to those affiliate links. Just by clicking on that Amazon affiliate link, even if you don't buy what the link is for, just click it. And doing the Amazon shopping you were already going to do anyway. That'll kick back for it because you came there off my channel. Thank you for watching. Don't forget to subscribe.